The winter morning broke cold and clear over Washington as crowds began gathering outside the Supreme Court building hours before the scheduled oral arguments, their breath-forming clouds in the frigid air as they waited for the doors to open and the chance to witness what legal observers had been calling the most consequential religious liberty case in a generation. The case concerned the tension between anti-discrimination protections for LGBTQ individuals and religious objections to providing services for same-sex weddings, a collision of constitutional values that had produced bitter divisions across American society and would now require the Supreme Court to choose which rights would prevail when they came into conflict. The specific dispute involved a graphic designer who refused to create wedding websites for same-sex couples based on her Christian beliefs about marriage, arguing that compelling her to produce such websites would violate her First Amendment rights to free speech and free exercise of religion. Civil rights organizations countered that allowing religious exemptions from anti-discrimination laws would effectively license discrimination against LGBTQ individuals and other groups whom business owners might object to serving on religious grounds, recreating the kind of categorical exclusions from public accommodations that the civil rights movement had fought to eliminate. The gallery filled with an unusual mix of religious conservatives who had traveled from across the country to support what they viewed as fundamental freedoms of conscience and expression, LGBTQ advocates who understood that the case threatened hard-won protections against discrimination, and legal scholars who recognized that the court's decision would reshape the landscape of civil rights law in ways that extended far beyond the immediate parties. Representative Jasmine Crockett sat in the section designated for congressional representatives who had filed amicus briefs, her presence drawing attention from those who had followed her previous confrontations with Supreme Court justices, and her reputation for preparation that anticipated every possible argument and rebuttal. She had worked with constitutional law experts and civil rights attorneys to craft a brief that challenged the framing of religious liberty claims as simply protecting individual conscience rather than examining how such claims functioned to impose religious beliefs on others who did not share them. Her analysis drew on historical examples of how religious arguments had been deployed to defend slavery, segregation, and other forms of discrimination that Americans now universally condemned, suggesting that religious exemptions from anti-discrimination laws represented the latest iteration of using faith as justification for excluding disfavored groups from equal participation in society. The case had arrived at the Supreme Court through lower court decisions that had split on whether creative professionals could refuse services for same-sex weddings without violating state anti-discrimination laws that prohibited discrimination based on sexual orientation. The petitioner had never actually been asked to create a website for a same-sex wedding, but had filed a pre-enforcement challenge claiming that Colorado's anti-discrimination law violated her constitutional rights by potentially requiring her to provide such services in the future. This procedural posture raised questions about whether an actual controversy existed, and whether the court should be deciding abstract questions about hypothetical applications of law, rather than resolving concrete disputes where facts and contexts could inform analysis. The petitioner's attorneys argued that her work as a designer constituted expressive activity protected by the First Amendment, and that forcing her to create messages celebrating same-sex marriage would compel speech in violation of her religious convictions. They emphasized that she was not refusing to serve LGBTQ individuals generally, but only declining to participate in events that conflicted with her religious beliefs, drawing an analogy to forcing a Democratic speechwriter to write speeches for Republican candidates, or requiring an artist to create work with messages the artist found morally objectionable. The respondents in supporting amicus briefs countered that public accommodations laws prohibited businesses from categorical refusals to serve protected classes, regardless of the expressive nature of the services provided, that allowing religious exemptions would undermine the fundamental principle that commercial enterprises could not exclude customers based on status characteristics like race, sex, or sexual orientation, and that the petitioner's argument would logically extend to permit discrimination against interracial couples, religious minorities, or any other group that business owners claimed religious objections to serving. They pointed out that the petitioner remained free to express her views about marriage through her personal speech and religious practice, but that operating a business open to the public required compliance with generally applicable laws, prohibiting discrimination in commercial transactions. The brief that Jasmine Crockett had helped prepare went further than most others in examining the power dynamics underlying religious exemption claims, noting that such claims were rarely asserted by religious minorities seeking protection from majoritarian impositions, but rather by members of dominant religious traditions seeking permission to impose their beliefs on others through exclusion from commercial services, employment opportunities, housing, and other necessities of modern life. Justice Neil Gorsuch had established himself as one of the most reliable votes for expansive religious liberty claims and restrictive interpretations of anti-discrimination protections during his tenure on the court. His jurisprudence reflected a particular vision of constitutional liberty that privileged religious exercise and expressive freedom over equality values, and that treated anti-discrimination laws as potential threats to individual autonomy rather than as essential protections for vulnerable populations. His opinions often employed stirring rhetoric about the importance of pluralism and tolerance, while arriving at conclusions that effectively granted dominant groups permission to exclude minorities from full participation in society. Critics argued that Gorsuch's approach to religious liberty cases was systematically one-sided, finding constitutional violations when religious conservatives faced any governmental regulation, but showing little concern for how religious exemptions burdened third parties or undermined equality principles. His previous writings and speeches suggested he would view this case as presenting a straightforward question about whether government could compel individuals to express messages they disagreed with, and legal observers expected him to be among the most vocal and committed advocates for the petitioner during oral arguments. The proceedings began with the petitioner's counsel delivering an opening statement that emphasized the creative and expressive nature of website design and the fundamental principle that government cannot compel individuals to speak messages they oppose. Her presentation portrayed the case as about protecting artistic freedom and religious conscience rather than about discrimination, claiming that her client was simply asking to be left alone to operate her business consistent with her values, rather than seeking to impose those values on others. Several of the conservative justices nodded along as she spoke, with Justice Alito asking supportive questions about whether there were any limits to what government could compel people to say, and Justice Thomas inquiring about whether custom creative work should receive greater First Amendment protection than standardized commercial products. The liberal justices pushed back with questions about how to distinguish between services the petitioner claimed were expressive and services that were merely commercial, whether her logic would extend to other protected characteristics like race, and how LGBTQ individuals would access necessary services if business owners could categorically refuse to serve them based on religious objections. The Respondents' Counsel began her presentation by emphasizing that public accommodations laws were among the most important civil rights achievements of the past century, and that allowing religious exemptions would fundamentally undermine their purpose by permitting the very discrimination they were designed to prevent. She noted that many of the business owners who had resisted integration in the 1,960 seconds had claimed religious justifications for their refusal to serve black customers, and that the Supreme Court had rightly rejected such claims as inconsistent with the compelling governmental interest in eradicating discrimination. She argued that the same principle applied here, that preventing discrimination against LGBTQ individuals was a compelling interest that justified incidental burdens on religious exercise and expressive freedom, and that the petitioner remained free to express her views about marriage through countless other channels that did not involve discriminating against customers seeking commercial services. Her presentation was careful and well-reasoned, but legal observers noted that the conservative justices seemed less engaged with her arguments than they had been with the petitioner's counsel, asking fewer questions and showing visible skepticism toward her responses when they did engage. Justice Gorsuch intervened about 15 minutes into the respondent's presentation with a question that revealed both his substantive commitments and his confidence that the conservative majority would rule in favor of the petitioner. His tone carried an edge of impatience as he asked whether the attorney seriously maintained that government could force an artist to create work, celebrating events the artist found morally objectionable, and whether there were any limits whatsoever to governmental power to compel speech, as long as the compulsion was justified by anti-discrimination interests. The question was framed to make the respondent's position sound obviously unreasonable, suggesting that protecting LGBTQ individuals from discrimination necessarily required totalitarian governmental control over individual expression. The attorney attempted to explain that public accommodations laws did not compel speech, but rather regulated conduct in the commercial marketplace, and that businesses selling customized products to the public could not refuse service based on customer characteristics, any more than restaurants could refuse to serve food or hotels could refuse to provide rooms based on race, religion, or other protected traits. Gorsuch interrupted with a follow-up question that grew more pointed and dismissive, suggesting that the attorney was dodging his concern about compelled speech by hiding behind the commercial marketplace distinction. He pressed her on whether she acknowledged any difference between prohibiting discrimination in the provision of standardized products and requiring custom creative work that communicated messages, and whether First Amendment protections disappeared entirely once someone opened a business to the public. His questions were becoming less about genuine inquiry and more about advocacy for his preferred outcome, and the attorney struggled to respond in ways that addressed his premises without conceding the constitutional ground that would lead inevitably to his desired conclusion. The exchange was growing heated when Chief Justice Roberts recognized that there was a request to address a point of factual context related to Justice Gorsuch's questions about compelled speech and the scope of public accommodations laws. The chamber fell silent as Jasmine Crockett rose from her seat with the calm determination that had become her signature, approaching the lectern while Justice Gorsuch visibly tensed at the interruption to his line of questioning. "Justice Gorsuch," she began, her voice clear and controlled despite the tension in the chamber, "you have framed this case as being about whether government can force an artist to create speech celebrating events she morally opposes. I want to address that framing directly because it fundamentally mischaracterizes what public accommodations laws do and obscures the discrimination that such laws were designed to prevent." She paused briefly to ensure her opening had registered, then continued with the precise logical structure that had characterized her previous Supreme Court interventions. Public accommodations laws do not compel anyone to speak any particular message. They prohibit businesses from categorically refusing to serve customers based on protected characteristics. The distinction is crucial because it reveals that what is actually at stake here is not forced expression but rather permission to discriminate. The petitioner in this case is not being told what to say or what designs to create. She is being told that if she offers custom website design services to the public, she must offer those services to all customers regardless of their sexual orientation, just as businesses that offer services to the public cannot refuse to serve customers based on race, religion, sex, or disability. She could see Justice Gorsuch preparing to interrupt, but she pressed forward before he could speak, knowing that maintaining momentum was essential to establishing her argument's foundation. "You have suggested that requiring the petitioner to create wedding websites for same-sex couples is analogous to forcing a Democratic speechwriter to write Republican speeches or requiring an artist to create work with objectionable messages. But those analogies fail because they ignore the critical distinction between refusing a particular message and refusing a category of people. A Democratic speechwriter can refuse to write speeches supporting Republican policies for anyone regardless of their identity. What she cannot do under anti-discrimination law is refuse to provide speechwriting services to people because they are Republican, Christian, male, or any other protected characteristic. Similarly, the petitioner here is free to decline to create websites with specific messages she finds objectionable, regardless of who requests them. What she cannot do is refuse to provide the same services to same-sex couples that she would provide to opposite-sex couples simply because of who they are. Justice Gorsuch interrupted with visible frustration, his voice sharp, as he asked whether Crockett was suggesting that there was no speech being compelled, that creating a wedding website did not communicate any message about marriage. His question attempted to reframe her distinction as denying obvious facts about the expressive nature of custom creative work. But Jasmine had anticipated this exact objection and had prepared a response that would expose the logical flaw at the heart of his position. "I am suggesting, Justice Gorsuch, that the message communicated by a commercial website designer is not an endorsement of her customers' relationships or life choices, but rather a communication of information and images that the customers have requested as part of a commercial transaction. When a designer creates a website for a business, she is not endorsing that business's practices or products. When a photographer takes pictures at an event, she is not necessarily approving of the event's purpose or the participants' values. The expressive content in these contexts belongs to the customer, not the service provider, and treating commercial service provision as equivalent to personal endorsement conflates distinct categories in ways that would make anti-discrimination law impossible to enforce." She leaned forward slightly, her intensity building without losing its measured quality. "If we accept your premise that providing services constitutes speech, endorsing the customer's use of those services, then virtually every application of public accommodations law becomes constitutionally suspect. A restaurant serving interracial couples would be endorsing interracial marriage. A hotel providing rooms to unmarried couples would be endorsing non-marital relationships. A printer producing materials for a religious organization would be endorsing that religion's theological claims. The logical endpoint of your position is that any business owner who can characterize their services as remotely expressive can refuse to serve any customers they disapprove of for any reason, which would effectively nullify anti-discrimination protections altogether. She paused to let that implication resonate throughout the chamber. That cannot be what the First Amendment requires, because it would resurrect the segregated society that the civil rights movement fought to dismantle, only this time, the segregation would be justified by claims of artistic expression rather than explicit racial animus. Justice Gorsuch's expression had darkened, and his voice when he responded carried barely concealed irritation at having his reasoning challenged so directly. He stated that Crockett was ignoring the sincerity of religious believers who genuinely viewed participation in same-sex weddings as violating their faith commitments, and he suggested that her position showed hostility toward religion by treating religious objections as equivalent to racial prejudice. His response attempted to shift the discussion from legal logic to religious sensitivity, implying that questioning religious exemption claims constituted anti-religious bias. But Jasmine refused to accept that reframing, and her response demonstrated why conflating skepticism toward religious exemptions with hostility toward religion itself was a rhetorical sleight of hand designed to insulate religious claims from scrutiny. "Justice Gorsuch," she said firmly, "I am not questioning anyone's religious sincerity or suggesting that religious believers are motivated by prejudice. I am observing that religious beliefs, no matter how sincerely held, do not provide blanket immunity from laws that apply generally to everyone else, particularly when those laws serve compelling interests in preventing discrimination. The Free Exercise Clause protects religious belief and practice, but it has never been interpreted to require exemptions from neutral laws of general applicability that incidentally burden religious exercise, and for good reason." She continued before he could interrupt again, building an argument grounded in the court's own precedents and the historical record of how religious exemption claims had functioned throughout American history. This court held in Employment Division v. Smith that the Free Exercise Clause does not provide exemptions from generally applicable laws, even when those laws substantially burden religious practice. That principle has been settled law for over 30 years, and while Congress passed the Religious Freedom Restoration Act to provide greater statutory protections than the Constitution requires, RFRA still demands that religious exemptions not impose substantial burdens on third parties. Allowing the petitioner to discriminate against same-sex couples would impose exactly such burdens by denying them access to commercial services based on who they are, which is why courts have consistently rejected religious exemption claims when they function to perpetuate discrimination against vulnerable populations. She gestured toward the materials on the lectern before her, materials containing historical documents that her team had carefully compiled. The record of American history is unambiguous on this point. Religious justifications have been invoked to defend slavery, segregation, bans on interracial marriage, and exclusion of women from public roles. In every case, this court has eventually recognized that sincere religious beliefs do not justify imposing those beliefs on others through discrimination, and that protecting equality requires rejecting religious exemptions, even when believers genuinely view compliance with anti-discrimination laws as violating their faith. Justice Gorsuch leaned forward, his voice rising slightly as he asked whether Crockett was comparing people of faith to segregationists and suggesting that religious believers were bigots. His question employed a familiar defensive maneuver, treating any historical comparison between past and present religious exemption claims as insulting to contemporary believers, rather than as relevant evidence about how such claims have functioned across time. But Jasmine had faced this rhetorical tactic repeatedly in congressional hearings and courtrooms, and she had developed responses that acknowledged the emotional dimension of the issue, while refusing to let that emotion substitute for logical analysis. "I am not making moral judgments about individuals, Justice Gorsuch. I am making analytical observations about legal arguments. The fact that religious justifications were used to defend practices we now recognize as discriminatory does not mean that everyone who invokes religious liberty today is motivated by the same animus or prejudice. What it does mean is that religious exemption claims require scrutiny rather than automatic acceptance, because the mere fact that someone frames their position in religious terms does not establish that granting an exemption would be just or constitutional. History teaches that religious arguments can be deployed in service of discrimination just as readily as in service of justice, which is precisely why courts must look beyond the religious framing to examine the effects and implications of granting exemptions." She paused, then delivered an observation that would cut to the heart of Justice Gorsuch's entire approach to religious liberty cases. "The question before this court is not whether the petitioner's religious beliefs are sincere or whether she has the right to hold and practice those beliefs in her personal life and religious community. The question is whether operating a business open to the public gives her the right to impose her religious beliefs on customers by denying them services she would provide to others, and whether such imposition should be privileged over the government's compelling interest in ensuring that all citizens have equal access to commercial services, regardless of their sexual orientation. You have framed this as a case about protecting religious liberty, but from the perspective of same-sex couples who would be denied services, it is a case about whether their equality matters less than the religious preferences of business owners who disapprove of them. The First Amendment protects religious exercise, but it does not establish religion as trump card that automatically prevails over competing constitutional values like equal protection and equal dignity. Justice Gorsuch attempted to interrupt with a question about whether tolerance had any meaning if people with religious objections were forced to violate their conscience, but Jasmine continued speaking, her voice rising just enough to maintain control of the exchange without appearing disrespectful to the court. Tolerance, Justice Gorsuch, is not the same as endorsement, and it does not require society to accommodate every objection that individuals might raise to laws designed to protect vulnerable populations from discrimination. True tolerance means accepting that we live in a pluralistic society where people hold different beliefs about contested moral questions, and where the solution to that disagreement is not to allow some people to exclude others from public life, but rather to ensure that everyone has equal access to participate regardless of their beliefs or characteristics. She looked directly at him, her gaze steady and unwavering. The petitioner remains completely free to believe that marriage should be between one man and one woman. She is free to express that belief through her speech, to practice her faith in her religious community, and to refuse to personally marry someone of the same sex. What she is not free to do is leverage her religious beliefs to deny commercial services to people whose marriages she disapproves of, any more than a religious business owner who believes interracial marriage is sinful would be free to refuse services to interracial couples. The comparison to interracial marriage clearly struck a nerve, as Justice Gorsuch immediately responded that such comparisons were inflammatory and inapt because opposition to same-sex marriage rested on religious teachings that predated contemporary political debates, whereas opposition to interracial marriage had been fringe position even among religious communities. His response revealed discomfort with the parallel but failed to articulate a principled distinction that would explain why religious objections to same-sex relationships deserved constitutional protection, while religious objections to interracial relationships did not. Jasmine seized on this weakness with a response that would become the most quoted moment of the entire oral argument. "Justice Gorsuch," she said, her voice carrying both passion and precision, religious opposition to interracial marriage was not a fringe position. It was mainstream doctrine in many white Christian churches for generations, defended through extensive biblical interpretation, claiming that God had separated the races and forbidden their mixing. Bob Jones University maintained a ban on interracial dating until 2000, justifying that ban on religious grounds. When the Supreme Court upheld the revocation of that university's tax-exempt status in 1983, the university did not abandon its religious convictions. It simply lost the ability to impose those convictions on students while receiving government subsidies. She continued without pause, building toward a conclusion that would expose the fundamental flaw in Gorsuch's entire approach. The parallel between religious objections to interracial marriage and religious objections to same-sex marriage is not inflammatory, it is instructive. Both objections claim grounding in religious text and tradition. Both are sincerely held by believers who view them as central to their faith. Both function to exclude disfavored groups from equal participation in society. The only material difference is timing. That opposition to interracial marriage has become socially unacceptable, while opposition to same-sex marriage retains significant social support. But constitutional rights cannot depend on whether discrimination has fallen out of favor or retains a constituency. Equal protection means equal protection, regardless of how many people would prefer to discriminate or how sincerely they claim religious justification for doing so. Justice Gorsuch sat back in his chair, appearing momentarily at a loss for how to respond to an argument that had systematically dismantled the logical foundations of his position. Before he could formulate a reply, Jasmine delivered the final line that would destroy his objection and reframe the entire debate. If this court holds that the First Amendment requires exemptions from anti-discrimination laws for religious objectors, you will not be protecting religious liberty, you will be licensing discrimination and calling it freedom, and future generations will judge that decision with the same clarity we now bring to judgments about religious defenses of slavery and segregation, recognizing that sincere religious belief does not justify imposing second-class citizenship on people whose lives and loves offend a believer's sensibilities. The silence that followed was profound and uncomfortable, with justices shifting in their seats and spectators throughout the gallery processing what they had just witnessed. Justice Gorsuch did not ask another question for the remainder of Crockett's time at the lectern, instead sitting in silence that communicated either deep reflection or profound frustration at having his reasoning challenged so fundamentally and so publicly. If you found this exchange powerful and want to continue following how legal battles over equality and religious liberty shape the lives of millions of Americans, subscribe to this channel right now and turn on notifications, because we will keep covering every development in these crucial cases that determine whether civil rights protections can be maintained in the face of religious exemption. Claims that threaten to undermine decades of progress toward genuine equality for all.